Hi, welcome to CLAT chat. Today means I am going to explain you about the notes on Maneka Gandhi versus Union of India. This case is very important to the civil service aspirants as well as to the aspirants of AoR examination and as well as the aspirants of CLAT 2020 because nowadays there shall be one or two questions from each and every competitive examinations which are related to law and also for the aspirants of civil services. These means the notes on familiar cases is very important. Very important. In the last classes, I explained you very clearly how to write the notes on various familiar cases, and I explained you about how to write the notes on the case one on the Bharti's case, as well as I explained you about the note how to write the notes on that SR Bombai's case also. Today, I am going to explain you about how to write the notes on Maneka Gandhi versus Union of India. See, already I told you that if you want to write the notes on any case, means any familiar case or any case given by the paper setters or given in any examination, you have to focus on five things. Those are, first one is facts of the case, and the second one is issues in that case, and the third one is arguments of the petitioner, and the fourth one is arguments of the respondents or respondents, and the last one is judgment or highlights in the judgment. These are the five important points you have to focus to write the notes on familiar cases. If the question is short answer question, you can write a answer in brief. If the question is long answer question, just like as for the civil service aspirants, then you have to explain each and every part of these five in detail to get more marks. So, while coming to the case of Maneka Gandhi versus Union of India, you know that it is very important because it became very familiar since 1980. There are two things behind this case to become familiar. First one is Maneka Gandhi is the daughter-in-law of late Srimati Indira Gandhi. That is one aspect. And the second issue is it is related to the fundamental rights. It is related to the fundamental rights of a citizen. So on these two grounds, this case became very familiar since 1980. While coming to the first one, that is facts of the case. The facts of the case are passport was issued to Maneka Gandhi on 1/6/1976 by the passport authorities. But within a week, it was impounded. What is the reason behind? That is secondary, but actually the reason is that there is some dispute between late Srimati Indira Gandhi as well as Srimati Maneka Gandhi. Hence, on the instructions of Srimati Indira Gandhi, the passport officers were impounded the passport of Maneka Gandhi. That is the reason, but that is secondary because that is not mentioned in this case at anywhere. So actually, here the facts of the case are, first one, the passport was issued to Maneka Gandhi on 1/6/1976 by the passport authorities, and it was impounded by the passport authorities within a week. When Maneka Gandhi wrote a letter to the concerned authorities, means submitted a representation to the concerned authorities for the reason against impounding her passport, there is no proper reason by the passport authorities. They simply informed her that her passport was impounded because of in the interest of public, as well as according to the section 10(3)(c) of Passport Act, they need not disclose reasons in details. They need not disclose reasons in detail. That is the reply by the passport authorities related to impounding her passport. Agreed by the action of the passport authorities, Maneka Gandhi filed writ petition before the Supreme Court under Article 32. Under Article 32. Here that is very much important because generally writ petitions were filed under Article 226 before Honorable High Courts. But here she filed the writ petition before the Honorable Supreme Court under Article 32. You have to learn that any citizen, if the fundamental rights are affected, he can approach either the High Court under Article 226 or the Supreme Court under Article 32. But what is the difference between this Article 226 and Article 32? I will explain you in some other class. Because there are some guidelines which cases can be filed before the Supreme Court directly under Article 32 and which cases to be filed before the Honorable High Court under Article 226. That I will explain you in some other class. Because if you file any case before the Supreme Court under Article 32, there may be a chance that Supreme Court may direct you go and file this writ petition before the concerned High Court, like that also. So what are the guidelines and what is the difference between Article 226 and Article 32 to file the writ petition either before filing High Court or before filing Supreme Court? I will explain you in the next class. So here she filed the writ petition before the Honorable Supreme Court under Article 32. These are the facts of the case. These are the facts of the case in Maneka Gandhi versus Union of India. In Maneka Gandhi versus Union of India. Now, second one. What are the issues in this case? What are the issues in this case is the second part. Second part means, already I told you, out of 5 parts, first part is facts of the case and the second part is issues in the case. The main issue in this case is that section 10(3)(c), right to travel abroad, receipts in Article 21 or not is the main issue. The main issue or the issue in this case is that right to travel abroad, receipts in Article 21 or not is the issue. So now what is the learned about the facts of this case as well as we learned about the issues in this case. Next, the third one, arguments of the petitioner. Here the arguments of the petitioner means main argument of the petitioner is that section 10(3)(c) of Passport Act is violative of Article 21. Means the passport authorities misused their power granted under section 10(3)(c) of Passport Act. Hence, it is violative of Article 21 is the main argument of the petitioner. Now the next one. You see, next one is arguments of the respondent. What are the arguments of the respondent? Here, the arguments of the respondents are, first one, they have power to impound the passport according to the powers granted to the passport authorities under section 10(3)(c) of Passport Act. In the interest of public is the first argument of the respondents. And the second arguments of the respondent is that the procedure established by law are very important even in Article 21 are the arguments of respondents in the case of Maneka Gandhi versus Union of India. Next, the last one, judgment. What are the highlights in the judgment, or what is the judgment of the Supreme Court in this case? Is the last one. Upon hearing the arguments of both sides, Supreme Court ruled that here 2 points are highlighted in the judgment of the Supreme Court. Those are, first one, right to travel abroad resides in Article 21. Means it is a part of Article 21. Means no doubt right to travel abroad is a fundamental right. Because it is a part of Article 21. It resides in the Article 21. So Supreme Court ruled that right to travel abroad resides in Article 21. However, Supreme Court cleared another thing, that the phrases which are in Article 21 are the Constitution of India. Those are procedure established by law to be read as due procedure of law. There is very much difference between the two phrases. First one, procedure established by law, and due process of law. Procedure established by law means whatever is the law, they can adapt however they like. Due process of law means what is the aim of the law, they have to implement it. This is the difference between these two. So Supreme Court cleared that the phrases which are in the Constitution, those are procedure established by law, even in Article 21 must be read as due procedure of law instead of procedure established by law. These are the highlights in the judgment of the Supreme Court passed in Maneka Gandhi versus Union of India. Hence this case become very familiar since 1980. Before end of this class, I will repeat the entire once again. The facts of the case are: passport was issued to Maneka Gandhi on 1/6/1976 by the passport authorities, and it was impounded within a week. When Maneka Gandhi submitted a representation to the authorities for the reason against impounding her passport, the reason provided by the passport authorities are very irresponsible. They had given the reply simply as they impounded that passport in the public interest under the power granted to him under Section 10(3)(c) of Passport Act. Aggrieved by the action of the passport authorities, Maneka Gandhi filed the writ petition before the Honorable Supreme Court of India under Article 32. These are the facts of the case. And issues in this case are: right to travel abroad resides in Article 21 or not is the issue. And the arguments of the petitioner are that Section 10(3)(c) of Passport Act violates Article 21 is the main and one and only argument of the petitioner in this case. And the arguments of the respondents are: The passport authorities means the respondents have power to impound any passport in the public interest, under the power granted to him by the Passport Act wide section 103C. Wide section 103C. However, the procedure established by law are very much important. Even in Article 21 are the main arguments of the respondents. Next, highlights of the judgment are important points in the judgment. Upon hearing the both sides' arguments, Supreme Court ruled that first one, right to travel abroad resides in Article 21, means right to travel abroad is a fundamental right. Next, second one, the phrases which are in the Constitution, those are procedure established by law must be read as due procedure of law. Due procedure of law means it should not be misused. It should not be misused. So these are the main important points in the judgment, and this is the procedure how to write notes on important cases like Maneka Gandhi versus Union of India. So we will learn about how to write the notes on some other important case in the next class. Till then, bye.